In this video presentation, we're considering manslaughter and we're looking at voluntary manslaughter. This is the first video presentation on diminished responsibility. There will be a second one on diminished responsibility and intoxication, but this is going to be our starting point. Now, for my students, what I want you to do is to make sure that you run through this whole presentation for our flipped learning purposes. I would like to see all the information handwritten, please, in your files, and you know that I will be doing a file check shortly with you. So please make sure that as you run through the information, that in the sequence that you find it, that information then is in your folders. Let's start again with this diagram, which you've seen before, homicide offences. Now you'll see that there's a pattern across this diagram. The actus reus for murder, voluntary manslaughter and involuntary manslaughter is the same, unlawfully causing the death of a human being. The mens rea for murder is intention to kill or cause GBH. And remember, Vickers is the authority case that you could use to illustrate that point, and you'll notice that for voluntary manslaughter the mens rea is also the same, intention to kill or cause GBH, and it is for involuntary manslaughter that component is actually different, where there is no intention to kill or cause grievous bodily harm. Some key diminished responsibility cases are these. Now, please make sure that you pause the presentation here and you look up as many of those cases that you can find, and please now include them in your case log. They are not the only cases we're going to consider, but they are some very key cases within this area. Okay, so there are three special and partial defences that reduce a murder charge down to a manslaughter charge, and they are firstly diminished responsibility, secondly loss of control, and thirdly suicide pact. Now we are only going to consider the first two for this syllabus, and they are diminished responsibility and loss of control. The Coroners and Justice Act 2009 is our key legislation here, and it introduced the new defence of loss of control, which got rid of provocation, and it modified the defence of diminished responsibility, which was not created by this act. As the law is new, old cases are going to be used for illustrative purposes only. Okay, so let me just remind you again, loss of control is a new defence. It replaced provocation. Diminished responsibility is not new. It was modified by the Coroners and Justice Act. Now there are two key points I want to start off with. Point number one is this: if a special partial defence like diminished responsibility or loss of control is successfully pleaded, it does not result in an acquittal. Okay, so please make a note of that. It does not result in an acquittal. What it does is do this: it reduces a murder charge down to a manslaughter charge. And why is this key information? It's key because then a judge does have the freedom to impose whatever sentence he or she feels will fit this particular defendant. Okay, so they can take into account reports and mitigating factors and all kinds of things. So it reduces a murder charge down to a manslaughter charge. If it didn't, and it didn't reduce the charge down and it remained a murder charge, then we'd be faced with a mandatory life sentence. And then the second key point is that special defences are different to general defences in that they only apply to a murder conviction. Okay, so both those points are two key points. Make sure that this information, as all the other information that follows, is in your notes. There's two ways of doing this. You could either watch the whole presentation through and write down any questions that you would like to ask me in class, or pause as I go through each component of information and then write it into your notepads. Okay, I'm now moving on to the definition of diminished responsibility. Now, under Section 2 of the Homicide Act 1957, as amended by Section 52 of the Coroners and Justice Act 2009, the defendant must prove that at the time of the killing he was suffering from an abnormality of mental functioning which A. arose from a recognised medical condition, B. substantially impaired the defendant's ability to 1. understand the nature of his conduct, or 2. form a rational judgment, or 3. exercise self-restraint. And then the final component, that it provides an explanation for the defendant's acts and omissions in doing or being a party to the killing. You will need to memorise this definition, and I will be testing you without notes that you're able to write out this definition. So please make sure that you're aware of that. That will happen pretty soon. Now let's have a look at diminished responsibility in a diagram format. So the definition in a diagram format would look like this. So our key section is Section 52 of the CJA, Coroners and Justice Act 2009. Now, the evidential burden is on the defence, and the defence can only the defence of diminished responsibility, it can only come into play once the prosecution have proved the actus reus of murder, the actus reus and mens rea of murder first. Okay, so the prosecution prove the AR and the MR of murder first, and then the evidence is on the defence to prove diminished responsibility on the civil standard of proof, which is a balance of probability, and this is done using medical evidence. But the components are here, and the first component is that the defendant is suffering from an abnormality of mental functioning, and we will start by looking at this. That the abnormality of mental functioning is caused by a recognised medical condition. Okay, and that this substantially impaired their ability to do one of three things. Let me remind you what those three things are again. And they were to firstly understand the nature of the defendant's conduct, secondly to form a rational judgment, and thirdly to exercise self-control. And then that final element is that it provides an explanation for the conduct, and that last point is to do with causation. And we are going to look at each of these one by one. So what we're saying then is that a person may know what they are doing and they intend to do it, but they are suffering from a mental abnormality, which means that they may not be held responsible for the actus reus. So, an abnormality of mental functioning, what is this? In the case of Byrne, this was defined as a state of mind so different from that of ordinary human beings that the reasonable man would term it abnormal. So we need medical evidence to support the claim because, as I said a few moments ago, the evidence is on the defence to prove diminished responsibility on a balance of probabilities, and they will have to do this through medical evidence. And then the jury will have to be satisfied that the defendant's abnormality arose from that recognised medical condition. So ultimately, it is going to fall on the jury to make the decision. So the abnormality of mind involves a recognised medical condition. This will involve the medical profession for their expert opinions, and then the jury will make a decision once they've considered all the evidence that's been put forward by the doctors. And for this point, if you add Sanders 1991 and Campbell 1997, they are your authority cases for the point that's just been made. So here are a number of recognised medical conditions, and they are much wider under the Coroners and Justice Act 2009. So if you look at what's on that screen there, you can see a whole array of disorders, medically recognised disorders. Some of them are probably going to be quite new to you, like Othello syndrome. Paranoia you will have heard of, psychopathy, battered women syndrome you may not have, Aspergers syndrome you probably have, postnatal depression, PMT, extreme mental stress. And we're going to have a look at some of these. Okay, so postnatal depression, Rv Reynolds 1988. I'm not going to run through each of the cases in terms of what happened in each of those. I will leave it to you, however, to look up as many of those cases as possible, but I will deal with a few of them. Now, postnatal depression, the key case here is Rv Reynolds in 1988. Now, this case was about a 19-year-old defendant who battered her mother to death with a hammer. Now, she was suffering from postnatal depression, and she was successfully able to plead this under diminished responsibility. PMT. Okay, so this is premenstrual tension. R versus English 1981. In this case, the person was able to plead PMT under diminished responsibility, also successfully. Depression. Now, Sears and Gittins. Gittins is a case that I'm going to look at in our second video presentation when we look at diminished responsibility and intoxication. However, if you have already looked at it, that is useful. There's a whole series of cases that looks at both depression and intoxication, cases like Doshman and Gittins and Tandy. So we'll consider those in our second video. Post-traumatic stress disorder, key cases being Bradley 2007 and Gray 2003. Now, post-traumatic stress disorder used to be known as shell shock, and it was often found in soldiers. It was successfully pleaded in 2003 by Kerry Gray when he stabbed to death a pedestrian who had stepped into the path of his car. Now, Gray was a survivor of the 1999 Paddington rail crash, and what you'll find next is that I have an image of that story. So if you have a look at this, a man who claimed the Paddington train crash turned him into a killer. He stabbed a man to death and blamed his actions on trauma that he suffered in the Paddington train crash. So he was pleading post-traumatic stress disorder. He claimed he'd been perfectly normal until his personality was transformed by the accident. And then 2 years later, still suffering from this syndrome, he kills John Boltwood, father of two, who was drunk and had actually tapped on Gray's car window. In 2003, at his trial, Gray admitted manslaughter on the grounds of diminished responsibility, and he was ordered to be held indefinitely in a secure mental hospital where he remains. Epilepsy, Rv Campbell, 1997. Now, let me just go back to epilepsy again, actually. This is more like a physical disorder, but you'll find that both psychological and physical disorders can come into diminished responsibility. Paranoia, Rv Martin, 2001, the very famous case about the Norfolk farmer who was convicted of murder after killing an intruder, but he successfully pleaded paranoid personality disorder under diminished responsibility for that killing. Psychopathy R versus Byrne, 1960 case. He was suffering from very powerful urges in which he strangled and mutilated a young woman. He knew what he was doing, but he found it difficult to control his urges. And it's often the Byrne case that's used for that very first element when we look at what is abnormality of mental functioning. Battered Women Syndrome, Ahluwalia 1992, Thornton 1995, again very famous cases. A whole film has been based around Ahluwalia called Provoked, which if I have time I will show you, but if I don't, it's readily available. And both those cases I'm going to look at when we look at loss of control, and you will find that these cases actually overlap into both areas, both diminished responsibility and loss of control. And you'll find that in the exam, if you're writing about diminished responsibility, you'll very often find yourself writing about loss of control as well. Aspergers syndrome, R versus Reynolds. And Othello syndrome, R versus Vinagre, 1971. Now, in 1979, in R versus Vinagre, the defendant killed his wife after suspecting her of having an affair. He said he suffered from Othello syndrome, and this is a recognised psychological disorder. It involves feelings of very extreme jealousy without any or very little foundation. And the judge wasn't very happy about having to recognise this known medical condition, but nonetheless it's a known medical condition, which means it had to be recognised, and the defendant was able to successfully plead it. Extreme mental stress, R versus Freeney, 2011. Now, the jury accepted diminished responsibility in this case, and this was about a woman who had murdered her severely autistic child. And the jury accepted that she was suffering from extreme mental stress. Okay, so a whole array, as you see, of recognised medical conditions. And I know I've written there recognised mental conditions, but it's more correct to actually call them medical conditions. Okay, let's have a look at that diagram again. Diminished responsibility. Section 52. Make sure you commit that to mind. It is Section 52. Coroners and Justice Act 2009. Evidential burden on the defence. Remember, after the prosecution have proved the AR and MR murder. And then it's for the defence to prove diminished responsibility on a balance of probabilities through medical evidence. Let's look at that third component now. So the recognised medical condition that causes the abnormality of mental functioning must have substantially impaired the ability of the defendant to do one or more of the following. Remember, it doesn't have to be all three. It's one or more of the following. The first one, the ability to understand the nature of the conduct. For example, the defendant is suffering from delusions, which means they don't understand the nature of their conduct if they're suffering from delusions. They may believe, for example, that God has asked them to kill a person or persons. Their ability to form a rational judgment. A defendant who is suffering from battered women syndrome, paranoia, schizophrenia may not be able to form a rational judgment because any of those conditions would actually interfere with their ability to think reasonably, rationally. And then thirdly, it substantially impairs their ability to exercise self-control. So Byrne, the sexual psychopath, there was medical evidence to show that he couldn't control, he found it very difficult to control his perverted desires. So remember, it's one or more of those things. Okay, so if we now look at that final component, that this provides an explanation for the conduct. And before we actually look at that final component, let's just have a look at an overview of everything we've said so far. So in our first box here, abnormality of mental functioning. When you mention this, Byrne is your key case, and remember that quote should be one that you memorize. It's a state of mind so different from that of ordinary human beings that the reasonable man would term it abnormal. Okay, it arises from a medical condition. This covers psychological and physical conditions. Our psychological conditions could be battered women syndrome, paranoia, depression, mental deficiency, bipolar, post-traumatic stress disorder, Othello syndrome, extreme mental stress. Physical conditions are things like epilepsy, sleep disorders and diabetes. And substantially impaired, according to Lloyd in 1967, the Court of Appeal held that this does not mean total or trivial or minimal. It's something in between, and it's for the jury to decide. And Lloyd was confirmed in the 2011 Brown case. And what must be substantially impaired is one of three things: the defendant's ability to understand the nature of his conduct, their ability to form a rational judgment, or their ability to exercise self-restraint. So it's one of three things. So the final element needs to be considered now, that the abnormality of mental functioning provides an explanation for the defendant's acts and omissions. And this is where we look at causation again. The defendant has to prove diminished responsibility on a balance of probabilities and not beyond all reasonable doubt. So it's a civil standard, not a criminal one. This means that as long as the jury are sure that the defendant was suffering from diminished responsibility at a 51%, then they may find the defendant guilty of manslaughter and not murder. Okay, in summary, 1. Abnormality of mental functioning. A mind so different from that of ordinary human beings that the reasonable man would deem it abnormal, Byrne being the authority case. Point 2, in summary, substantially impaired. Impairment doesn't have to be total, it's got to be more than minimal. Lloyd confirmed in the later case of Brown. Remember, it's one of those three things. So, substantially impairs the defendant's ability to do one of three things. Those are: 1, to understand the nature of their conduct. I can see that understand has been spelled wrongly there. To form a rational judgment, to exercise self-control. And the final element, the abnormality of mental functioning, provides an explanation for the defendant's acts. It's a causation issue, as a defendant wouldn't have killed if they were not suffering from the medical condition. Okay, so remember what I said about everything when it comes down to the elements. The elements are always discussed in the order that you learn them. Okay, so remember there are 4 components here, and you run through each of the components in order. And once you have written down all of this information, you understand it, we will be having a look at it in class, and there will be a second video to follow, which is to do with diminished responsibility and intoxication. Thank you for following this video through, and please make sure that you have all the cases as well as all the information.